Tonight, the Trump administration is working on Plan B after the Supreme Court struck down Plan A and ruled that his sweeping emergency tariffs are illegal and not an emergency. The rare and stinging loss for the president at the high court is a major victory, actually, for my next source. He argued this very case against the president's tariffs in front of these justices and won. Neil Katyal is the plaintiff's lead attorney, the former acting solicitor general, and who has argued more than 50 cases before the Supreme Court. Neil, I think a big question people have is, where does this one rank for you?
Hey everyone, Dr. John here. So this is what's happening right now. The Supreme Court just lit a fuse. And what it is burning toward is not just Donald Trump. It is his entire cabinet, every single one of them. The Secretary of Defense, the National Security Advisor, the Treasury Secretary, the Commerce Secretary, the Vice President, all of them simultaneously. On multiple legal fronts at once. Domestic courts, international tribunals, civil discovery, war powers challenges.
Well, I don't think, Caitlin, first of all, thank you for having me on. I don't think this is about me or my victory. I think it's a victory for the Constitution, for our founders' vision of what America is, which is to recognize that sometimes our leaders are going to be overly ambitious, overly aggressive, and the system they designed creates the opportunities for self-correction. And it takes guts. And here we had guts, not by me, but by a group of small businesses that stood up and said, hey, this isn't what America's about. And so they did what a lot of our nation's biggest companies were afraid to do, which is take the president on these sweeping, unprecedented tariffs, and they won.
Closing in from every direction at the same time. This is not a single ruling about a single policy. This is the moment where the legal system stops asking whether Trump broke the law and starts asking whether his entire administration did. And the answer coming back from courts, from legal scholars, from international prosecutors, and from inside the administration's own officials is yes. Let's walk through every piece of it. Start with the Supreme Court ruling itself, because everything that follows flows directly from it.
And they won not just in some partisan decision or something like that by a bunch of Democrats. No, they won in the Supreme Court of the United States, which is, and they won, with two of the President Trump's three appointees to the Supreme Court siding against President Trump. So it was a sweeping victory, not for us, but for the rule of law.
Well, and how did those small businesses feel when this came down today? I mean, obviously everyone had been waiting and waiting to see what the court would decide. When they were looking through this decision, what was their reaction?
The court ruled 6-3 that Trump violated federal law by using the International Emergency Economic Powers Act to impose sweeping tariffs across the board. 6-3, not close, not a narrow procedural dodge, a decisive substantive ruling that Reuters, the Associated Press, and NPR all described in identical terms. A major defeat and a sharp rebuke. The court did not merely disagree with the policy.
Yeah, gratified and vindicated. And it's hard for these businesses to do this. It's not like they're fancy with a lot of money and extra cash lying around. So this is, it's hard on their families, and yet they stepped up and did the right thing, and they made an incredible difference. And for me, it was just the privilege of a lifetime, as the son of immigrants, to be standing before the Supreme Court, making an argument rooted in our constitutional history, rooted in what Alexander Hamilton and James Madison thought about the way our Constitution is supposed to work. There's no greater honor that I could imagine.
It condemned the legal theory behind it, using language about executive overreach that legal scholars immediately flagged as extraordinary in its scope and directness. But here is where the story detonates into something far bigger than a single court loss on trade policy. The ruling did not end the tariff program. The administration pivoted immediately, almost reflexively, to alternative statutory authority, trying to keep the tariffs alive under a different legal justification.
I think you make a good point about how it affected these small businesses on a day-to-day basis to deal with not just the tariffs, but also the uncertainty of them and, how much they changed and they would go up and go down or kind of on the president's whims. I was reading about one small business owner who spent $50,000 in tariffs as they were just building their products. For them tonight, the question about a refund is a real one. It's some $134 billion. What did you make of the fact that the Supreme Court left that unsettled in the ruling today?
So the Supreme Court, Caitlin, gave us everything we asked for. We made 6 basic arguments in the case. They accepted all of them, not at 90%, but at 100%. With respect to the refunds, Our plaintiffs in our case, the government has already conceded will get the refunds. And with respect
And within days of that pivot, 24 states filed suit in the Court of International Trade, arguing that the alternative authority is just as unconstitutional as the original, that the Supreme Court's ruling did not just strike down one legal pathway, it established a constitutional principle about the limits of executive emergency power that the alternative approach violates just as directly. 24 states, days after the ruling. That is not a slow-moving political response. That is a coordinated legal avalanche. And sitting on top of it, more than $130 billion in tariff refund exposure. Because every dollar collected under a program the Supreme Court just declared illegal is potentially a dollar that has to be paid back to businesses, to corporations, to the companies that absorb those costs for months while the legal challenges work their way through the system. $130 billion. That is the financial scale of what the Supreme Court's ruling actually means in concrete terms. And then FedEx sued, along with other major corporations, not just challenging the policy in the abstract, not just seeking a court declaration that the tariffs were illegal, but filing specific refund suits demanding the money back. And those suits do something that no congressional hearing, no political investigation, no presidential press conference can do. They trigger discovery. This is the part that the administration's lawyers understand most acutely and most fear most deeply. Civil discovery in commercial litigation is not like congressional oversight. When a senator sends a letter asking for documents, the administration can stall, claim privilege, send carefully managed testimony, and control the narrative through strategic communication. When FedEx's legal team is entitled to documents and depositions under federal discovery rules, the rules are different. The obligations are enforceable by courts. The production requirements are comprehensive, and the officials being deposed, the economic advisors, the trade officials, the cabinet members who planned and justified and implemented this program are sitting across a table from opposing counsel, under oath, answering specific questions about specific decisions, with perjury consequences attached to every word. The internal deliberations that the administration has worked hardest to keep out of public view are exactly what civil discovery is designed to surface. The communications between cabinet officials about whether the legal authority was solid. The internal assessments about whether the remarkable authority claim would survive judicial review. The emails and memos and meeting notes that document whether the people making these decisions knew the ground was legally shaky and pushed forward anyway. All of that is now potentially accessible to FedEx's lawyers in ways that the most aggressive congressional oversight has been specifically prevented from reaching. When administration economic officials sit down for depositions in this litigation, they are not appearing before a friendly committee with allies in the room. They are being examined by opposing counsel whose entire job is to find the contradictions, surface the damaging documents, and expose the gap between what officials said publicly and what they actually knew and discussed privately. That accountability dimension, oath-bound, discovery-driven, enforced by federal courts rather than political processes, is the single most consequential mechanism the tariff chain reaction has produced, and it is just getting started. Now let's move to the second front, because this is where the story expands from trade policy and economics into something with far graver consequences. The unilateral military assault on Iran has triggered its own legal reckoning, and the legal scholars analyzing what comes next are saying something that should stop everyone in their tracks. If the Supreme Court takes up a war powers challenge to the Iran strikes, and the calls for exactly that are growing louder by the week, the ruling would not just address whether the president exceeded his constitutional authority. It would rule on the specific decisions made by the defense secretary, the national security advisor, every senior official whose authority and whose specific choices were directly involved in planning, coordinating, and executing those strikes. This is the distinction that makes the Iran war powers question categorically different from the tariff case. The tariff ruling implicated the economic cabinet, the officials who advised, designed, and implemented the trade policy. A war powers ruling implicates the national security cabinet, the people who ordered the strikes, planned the operations, and committed the country to unauthorized military action. These are not bureaucrats with procedural exposure. These are the people who made the specific life and death decisions about whether and how to bomb another country without the constitutional authorization that the law requires. A Supreme Court ruling on the Iran Iran war, Powers' question would establish a constitutional accountability framework that extends to every one of those officials, not just a declaration that the president went too far, a ruling on whether the defense secretary had the authority to order the strikes he ordered, whether the national security advisor's coordination of those operations fell within legal limits, whether every cabinet-level decision that produced those specific military actions was constitutionally sound. The entire national security apparatus, the whole decision-making chain from the Situation Room to the strike orders, subjected to the most rigorous constitutional accountability a court can impose. Legal scholars are not warning about this as a remote theoretical possibility. They are describing it as a direct and foreseeable consequence of the legal architecture being constructed around the Iran war powers challenge. The calls for courts to clarify presidential war powers limits are coming from serious legal institutions, not fringe critics. And the implications of a court that has already shown a willingness to issue sharp rebukes of executive overreach taking up a case about the most consequential national security decisions of this administration, those implications extend to every person who sat around that table when those decisions were made. Now let's go to the third front, and this one has a global dimension that fundamentally changes the nature of the accountability picture. U.S. officials have confirmed, openly, on record, that there is active chatter in the international legal community about prosecuting the vice president and senior members of the National Security Cabinet for war crimes related to Iran. And the administration's response to that chatter is the most self-revealing action it could possibly have taken. They are lobbying the International Criminal Court to exempt Trump and top officials from future war crimes prosecutions. They sanctioned ICC judges and prosecutors. They are spending serious diplomatic capital trying to slam that door shut before it opens any further. Think about what that behavior tells you. Governments do not spend political resources seeking immunity from prosecutions for crimes they are confident their officials did not commit. You do not lobby for an exemption from accountability you believe you do not face. The ICC lobbying campaign is not a routine diplomatic maneuver. It is a specific, targeted, aggressive effort to prevent a specific accountability outcome that the administration's own officials have privately assessed as credible. The open chatter about prosecuting the vice president and cabinet members is not hostile rhetoric being dismissed internally. It is a credible legal threat being taken seriously enough to trigger the most aggressive available international maneuvering to prevent it. And here is the detail that makes the ICC dimension uniquely alarming beyond the presidential exposure. The prosecution chatter is not limited to Trump. The specific officials being discussed in international legal circles are the vice president and senior cabinet members. These are people whose accountability before an international tribunal does not depend on presidential immunity arguments. Presidential immunity, the domestic legal doctrine that has shielded Trump from certain accountability in American courts, does not transfer to cabinet officials in the same way. Their exposure at the ICC depends on the specific conduct of the official acts they performed. And the open chatter confirms that international legal experts assessing that conduct have concluded there is a credible case. Add to all of this one more devastating layer. The New York Times documented that Trump-driven purges of the DOJ and FBI have gutted the national security and public corruption units that would normally serve as internal accountability mechanisms. The professionals whose institutional function is to flag legal problems, investigate misconduct, and maintain the rule of law within the executive branch have been systematically removed, which means the only accountability mechanisms left that have teeth are the ones outside the administration's control: the courts, the civil litigants, the international legal community, the very mechanisms that are now simultaneously closing in from every direction. This is what the phrase "power ends" actually describes. It is not a dramatic metaphor. It is a precise description of what happens when every external accountability mechanism activates at the same moment against every level of an administration. Not just its head, the tariff chain reaction reaching cabinet economic officials through discovery. The war powers challenge potentially reaching the entire national security cabinet through a Supreme Court ruling. The ICC chatter reaching the vice president and senior cabinet members through international legal pressure. 3 independent fronts, 3 separate legal architectures, all of them pointed at the same target. Not Trump alone, but the entire governing apparatus he built. So where do things go from here? There are 4 specific developments to watch as this multi-front legal assault continues to escalate. First, the Court of International Trade and the 24-state lawsuit. Whether courts find that the alternative tariff authority is just as constitutionally equally defective as the original is the next major decision point in the tariff chain reaction. If the alternative authority is struck down, the administration has no remaining legal shelter for the tariff program, and the $130 billion refund exposure becomes the dominant financial reality of the second term. The FedEx discovery proceedings. Whether the internal communications about the tariff program's legal vulnerability are produced in ways that document what economic officials knew, and when they knew, it will determine whether the cabinet's decision-making receives the kind of independent scrutiny that congressional oversight has been prevented from providing. The depositions of economic officials are the accountability mechanism to watch most closely. The Iran war powers question at the Supreme Court. Whether the court accepts a case that would rule on the specific decisions of the Defense Secretary, the National Security Advisor, and the other senior officials who planned and executed the Iran strikes is the highest stakes pending legal question in the entire story. A decision to take that case would extend constitutional accountability to the full National Security Cabinet in ways that have no precedent in modern American history. The ICC lobbying outcome. Whether the administration's aggressive diplomatic campaign to exempt its officials from international prosecution succeeds in closing that door, or whether the open chatter about prosecuting the vice president and cabinet members advances into a formal process, will determine whether the accountability picture is resolved entirely through domestic legal mechanisms or through the most dramatic available combination of domestic and international accountability arriving simultaneously. Here is the bottom line that every piece of this story adds up to. The Supreme Court ruled 6-3 that the tariff program violated federal law. Over $130 billion in refund exposure followed immediately. 24 states sued within days, challenging the alternative tariff authority. FedEx and other corporations filed refund suits, putting economic cabinet officials under oath in discovery. The Iran war has triggered calls for war powers clarification that legal scholars say could result in Supreme Court rulings on the specific decisions of the Defense Secretary and National Security Advisor. The administration is lobbying the ICC to exempt its officials from war crimes prosecution, while its own officials admit the prosecution chatter about the vice president and cabinet members is real. And the internal accountability mechanisms that might otherwise manage these pressures have been deliberately destroyed through systematic purges of the DOJ and FBI. This is no longer a story about whether one man exceeded his authority. This is the story of an entire cabinet whose collective exercise of power is being subjected to the most comprehensive available legal accountability from domestic courts, international tribunals, and civil litigants simultaneously. The Court of International Trade proceedings are active. The discovery is underway. The war power's legal architecture is being constructed in real time. The power ends not with a single ruling. It ends when every institution that can say no says it at once.